Discharge of contract. Discharge of contract means the termination of contractual obligations between the parties. When a contract is discharged, the parties are no longer legally bound to perform their promises. A contract may be discharged in several ways, such as by performance, mutual agreement, impossibility of performance, lapse of time, operation of law, or breach of contract. The most common way of discharge is performance, where both parties fulfill their obligations. In some cases, a contract may also come to an end due to events beyond the control of the parties, such as death, destruction of subject matter, or change in law. Thus, discharge of a contract brings an end to the legal relationship created by the contract under the Indian Contract Act, 1872. Modes of discharge of contract. A contract may be discharged in various ways under the Indian Contract Act, 1872. The most common mode is discharge by performance, where both parties fulfill their promises and the contract comes to a natural end. Discharge by performance. When both parties fulfill their promises, the contract is discharged naturally. This is the best and normal way of discharging a contract. Discharge by performance occurs when both parties to a contract fulfill their respective promises according to the terms of the contract. Once performance is complete, the contract comes to a natural end and no further obligations remain. This is the best and most normal mode of discharging a contract. Performance may be actual, where the parties actually perform their promises, or attempted, where one party offers to perform but the other party refuses to accept it. In both cases, the contract is treated as discharged. Thus, discharge by performance brings a lawful and complete end to contractual obligations under the Indian Contract Act, 1872. Discharge by mutual agreement, Section 62. Discharge by mutual agreement takes place when both parties to a contract agree to end, modify, or replace the existing contract. According to Section 62 of the Indian Contract Act, 1872, a contract may be discharged by novation, rescission, or alteration. Novation means substituting a new contract for the old one, either between the same parties or with new parties. Rescission means cancelling the contract altogether. Alteration means changing the terms of the contract by mutual consent. When a contract is discharged by mutual agreement, the original contract becomes void and the parties are no longer bound by it. A contract may be discharged by novation, replacing old contract with a new one. Rescission, cancelling the contract. Alteration, changing terms of the contract. Remission, acceptance of lesser performance. A contract may be discharged by novation, replacing old contract with a new one. Novation means the substitution of a new contract in place of an old contract, with the consent of all parties concerned. Under Section 62 of the Indian Contract Act, 1872, novation may take place either by changing the parties to the contract or by changing the terms of the contract. When novation is made, the original contract is discharged and the new contract becomes binding. For example, if A owes money to B and B agrees to accept C as the new debtor in place of A, the original contract between A and B is discharged by novation. Thus, novation brings an end to the old contract and creates a new contractual relationship. Rescission, cancelling the contract. Rescission means the cancellation of a contract by mutual consent of the parties. Under Section 62 of the Indian Contract Act, 1872, when both parties agree to rescind the contract comes to an end and neither party is required to perform their obligations. Rescission may also occur when one party fails to perform and the other party chooses to treat the contract as cancelled. For example, if A and B agree to cancel their contract before performance, the contract is rescinded. Thus, rescission results in the complete termination of the contract. Alteration, changing terms of the contract. Alteration means a change in one or more terms of a contract by the mutual consent of both parties. Under Section 62 of the Indian Contract Act, 1872, when the terms of a contract are altered, the original contract is discharged and the altered contract becomes binding on the parties. The alteration must be material and agreed upon by all parties to the contract. For example, if A and B agree to change the price or time of performance in their contract, it amounts to alteration. Thus, alteration discharges the old contract and creates a new one with modified terms. Remission, acceptance of lesser performance. Remission means the acceptance of a lesser performance than what was originally agreed upon in the contract. According to Section 63 of the Indian Contract Act, 1872, the promisee may dispense with or remit, wholly or in part, the performance of the promise made to him. Remission can be made without any consideration and depends on the will of the promisee. For example, if B agrees to accept 8,000 Indian rupees in full settlement instead of 10,000 Indian rupees from A, it is a case of remission. Thus, remission discharges the promisor from performing the full obligation. Discharge by impossibility of performance, Section 56. Discharge by impossibility of performance occurs when the performance of a contract becomes impossible or unlawful after the contract is made. According to Section 56 of the Indian Contract Act, 1872, a contract becomes void when an act becomes impossible due to events beyond the control of the parties. Such impossibility may arise due to destruction of the subject matter, death or incapacity of a party, change in law, or natural calamities. For example, if a contract's to deliver goods but the goods are destroyed by fire before delivery, the contract becomes void. Thus, when performance becomes impossible, the contract is automatically discharged by law. Example, a contract's to sing, but dies before performance. Discharge by lapse of time. If performance is not done within the prescribed limitation period, the contract is discharged. Discharge by lapse of time occurs when a contract is not performed within the time prescribed by law. If the aggrieved party does not take legal action for enforcement of the contract within the limitation period specified under the Limitation Act, the contract becomes unenforceable. After the expiry of this period, the parties are discharged from their contractual obligations. For example, if A fails to file a suit for breach of contract within the prescribed time, he loses his legal remedy. Thus, lapse of time results in discharge of the contract due to inaction within the legal time limit. Discharge by operation of law. Discharge by operation of law occurs when a contract is discharged automatically due to the application of law, without any action by the parties. This may happen due to death of a party, insolvency, merger of rights, or unauthorized material alteration of the contract. For example, when a promisor is declared insolvent, he is discharged from further contractual liabilities. Similarly, if the rights and duties under a contract vest in the same person, the contract comes to an end. Thus, discharge by operation of law takes place due to legal consequences beyond the control of the parties. Discharge by breach of contract. Breach occurs when a party fails or refuses to perform its obligation. Discharge by breach of contract occurs when one party fails or refuses to perform his contractual obligations. When a breach takes place, the aggrieved party gets the right to treat the contract as discharged and may claim damages or other legal remedies. A breach may be actual, where a party refuses to perform on the due date, or anticipatory, where a party refuses to perform before the due date. For example, if A refuses to deliver goods on the agreed date, it is an actual breach. Thus, breach of contract results in discharge and gives rise to legal remedies under the Indian Contract Act, 1872. Types of breach. Actual breach, refusal on the due date. An actual breach of contract occurs when a party refuses or fails to perform his obligation on the due date of performance. When the time for performance arrives and one party does not perform as promised, the contract is said to be actually breached. In such a case, the aggrieved party can treat the contract as discharged and claim damages or other legal remedies. For example, if A agrees to deliver goods to B on the 1st of June but fails to deliver them on that date, it amounts to an actual breach. Thus, refusal or failure on the due date leads to actual breach of contract. Anticipatory breach, performance and discharge of contracts, an anticipatory breach of under the Indian Contract Act. One party refuses to perform his obligation before the due date of that contractual promises are fulfilled. This refusal may be expressed brings an end to contractual obligations through various legal methods. Breach occurs, a clear understanding has the option either to treat the contract the rights, immediately discharged and claim damages of the parties or to wait until the due date and see whether the other party performs. For example, if A agrees to supply goods to B on the 1st of July but informs B on the 1st of June that he will not supply them, it is an anticipatory breach. Thus, refusal before the due date amounts to anticipatory breach of contract. The aggrieved party can claim damages or legal remedy. Conclusion. Performance and discharge of contracts are essential concepts under the Indian Contract Act, 1872. Performance ensures that contractual promises are fulfilled, while discharge brings an end to contractual obligations through various legal methods. A clear understanding of these concepts helps in determining the rights, duties, and remedies of the parties in a contract and is highly important.